for incapacity. I'm going to talk about some pitfalls in senior planning. And then, as Christy said, I'm going to take questions at the end. And so if you can type those into the chat box, Christy's going to read them back to me at the end. Christy, you can hear me okay? Great. I'm going to then just dive into paying for long-term care and why it's important. And as you can see from this, the cost of long-term care nationally is really, really high. It's not as expensive here in Louisiana, but it still costs a lot of money if you need long-term care. So nursing home care, the average cost in Louisiana is close to $70,000 a year. That average cost includes the cost in the northern parishes where it's cheaper, in the New Orleans area where it might be a little more expensive. Here in the greater Baton Rouge area, nursing home care is going to cost about $72,000 a year, or about $6,000 a month. Assisted living care, the price can range greatly depending on what type of care you need. If you need just minimal care, then around $44,000. If you need Alzheimer's care or memory care in an assisted living, you could see the cost again going to $70,000, $80,000, $100,000 a year. Home care, about $40,000 a year for an 8-hour day. Of course, if you need somebody 24/7, that's going to triple or be over $100,000 a year. Adult daycare would be about $20,000. That's the average here in Louisiana. We don't have very much adult daycare here in the greater Baton Rouge area. So as you can see, paying for long-term care is very, very expensive. And for most people, it's hard to pay for those costs for very many years. And so we want to look at what things are available to help pay for the costs of long-term care. So a lot of people think their health insurance or their Medicare will pay for long-term care, but it will not. Medicaid will pay for long-term care. Mostly here in Louisiana, that's care that's provided in a nursing home setting. Medicaid does have something called home and community-based services where they will pay someone to come into your home, but there is a long waiting list for the home services here. And so for most purposes, if Medicaid is paying for long-term care, that's in a nursing home setting. As I said, you can pay out of pocket for care. You can also, if you have long-term care insurance, that will pay for nursing home care, assisted living care, home care. But most people don't have any long-term care insurance. There are also some VA benefits called aid in attendance that may be available if you meet the criteria. That type of care can also be, or those benefits can be used to pay for care at home, care in an assisted living, or care in a nursing home. And so I'm going to talk now about the Medicaid rules because that's one of the things that I get asked all the time. I meet with families and they have maybe somebody who's recently been diagnosed with Alzheimer's, maybe somebody in the later stages of Alzheimer's, and they know either that they're going to need care or it's likely they're going to need care one day, or maybe they already are in need of care. And so one of the things they want to know about is Medicaid and what will Medicaid pay for and what are the rules for Medicaid. Now I call these rules new. They're not really new. The Medicaid rules were adopted, the latest revisions to the law were done in 2006. They became effective here in Louisiana in 2008. But in lawyer years, that's relatively new because in lawyer years, it usually takes a long time for things to happen. And so let's look at what those rules are. So the Medicaid basics are that if someone needs nursing home care, or if they're trying to get those home and community-based services, if they are single, they can't have any more than $2,000 in countable assets. In a few minutes, I'm going to tell you what's countable and what's not countable. But just for now, remember that if they're single, they can't have any more than $2,000 in countable assets. If they are married, the spouse who is not in the nursing home, or the one who doesn't need care, can have an additional $128,000 $640 in countable assets. This limit for the spouse changes every year. And so this year it's 128,640. I recently saw the numbers for 2021. They're going to be somewhere 129, 130. This number goes up a little bit every year based on the cost of living. That $2,000 number stays the same. So the person who's in the nursing home can never have more than 2,000. The spouse outside of the nursing home, that number goes up a little each year. Those are asset limits. There's also an income limit to be categorically eligible for Medicaid. And what that means is that if your income is below $23.49 a month, then you meet the income test without going any further. If your income is greater than $23.49 a month, you may still qualify for Medicaid, but you have to go further and you have to look at the cost of care based against how much your income is. So more often than not, even if somebody's income is greater than $23.49 a month, as long as their income is less than the cost of nursing home care, they can still qualify under the income test. It's usually the assets that pose a problem. So one of the things that is not counted is your home, and your home's not counted if it's worth less than $595,000. Another important rule for Medicaid is that there is a penalty for giving assets away. And that penalty is 1 month for every $5,000 you give away. That penalty begins the date that you file the Medicaid application. And you can't file the Medicaid application until you need nursing home care. And so the penalty starts when you need nursing home care. It doesn't start when you make the gift. There's also something called a 5-year look-back period. And what that means is on the day you file a Medicaid application, Medicaid is going to look back for 5 years and see if you have made any gifts in those previous 5 years. If you have, then they're going to impose this penalty period. If you haven't made any gifts within that 5-year period, then you won't have any penalty. So those are the Medicaid basics. Let me talk now a little bit more about the details. And so when we're talking about income, Medicaid is going to look at all of the gross income, both earned income and unearned income. So if you were working, that would be earned income. It's very seldom that I have anybody who's working and who has earned income. Unearned income would be things like rental income or interest income or things like that. With regard to income, they're only going to look at the income of the person who needs care. And so when it says that it's normally attributed to the person whose name is on the check, they're going to look at, for instance, the Social Security benefit of the person who needs nursing home care. They're going to look at the pension, maybe a private pension of the person who needs care. They're not going to look at the income of the spouse who is outside of the nursing home. They're only going to look at the income of the person who needs nursing home care or who is applying for Medicaid. As I said, 2,000 in assets for the nursing home resident, an additional 128,640 for the person not in the nursing home. If both spouses are in the nursing home, then together they can only have $3,000 in countable assets. And so very quickly it goes from 130,640 when you've got one spouse in the nursing home and one spouse outside of the nursing home to $3,000 in countable assets if both spouses are in the nursing home. So what is Medicaid looking at as countable? Basically, they're looking at anything that you can convert into cash. So your bank accounts, your CDs, your investment accounts, your life insurance policies, if they have cash value. So your whole life policies, your universal life policies, not your term life policies because they don't have any cash value. They're going to look at your retirement assets, your IRAs, your 401ks, any annuities that you have. They're going to look at any real estate that you own other than your primary residence. and they're going to look at any assets that you hold in a revocable trust. And all of those things are going to be countable assets when they're looking to see if you're below that 2,000 or that 128,640. So for married people, they're going to count the assets regardless of whose name is on the title and regardless of whether Louisiana considers that community property or separate property. And so for jointly owned assets, they're going to always presume that it belongs to the Medicaid applicant. And you'd have to prove that by clear and convincing evidence that it was not. But the most important thing to remember here is that for married couples, everything that they own is going to be considered, regardless of whether it's separate property or community property, regardless of whether the spouses have entered into a prenuptial agreement. For Medicaid purposes, all of those things are countable assets. The things that are not countable, the equity in the home, and it looks like I don't have this slide updated for 2020, but the equity is limited to $595,000. So the first $595,000 is not a countable asset, the value of your home. But you have to be careful about that because there's something called estate recovery that I'm going to also talk about in a few minutes. Your automobile, one automobile of any value is not countable. I had a client many years ago, and he had a car that he used as his regular driving car, and he also had a classic Chevrolet 1950 something model Chevrolet that was worth about $50,000 or $60,000. For Medicaid purposes, he kept that car as his one automobile of any value. And so a lot of times people will keep two cars, but will use the one that's the most expensive as the one that's not countable. Also, the things that aren't countable are your household goods, your engagement and wedding rings, assets that you use in a trade or business. If you have a prepaid burial or a cemetery plot, that's not countable. Any life insurance with a face value of less than $10,000 is not countable. As I said, term life insurance of any value isn't countable. And then assets that are held in a special needs trust or an irrevocable trust where the Medicaid applicant doesn't have any right to them are not considered countable assets. A lot of times people come and see me and they say, well, you know, I'm my spouse, my mom, my dad needs nursing home care. Can't they just give me their house, or can't they just give me their assets so we can qualify for Medicaid? And unfortunately, giving things away can be a recipe for disaster because of the transfer penalty. There have been many times that I have had to go back and fix things where people gave something away and created a Medicaid penalty, either because they didn't know they were going to need Medicaid or because they got some bad advice and thought that they could do that. So the unintended consequence is that giving away assets or selling them for less than fair market value is going to result in a penalty of 1 month for every $5,000. And so if you gave someone a gift of $100,000 and you then applied for Medicaid, there's going to be a 20-month penalty. They're going to take the $100,000 gift, they're going to divide it by $5,000, and they're going to come up with a 20-month penalty where Medicaid is not going to pay for your care. Here in Baton Rouge, since care is about $6,000 a month, it's going to cost $120,000, 20 months times $6,000 to pay for care during that penalty period when you only got a $100,000 gift. And so again, a lot of times I've had to go back and reverse those gifts in order to get somebody qualified for Medicaid. So the other thing that people say is, well, I'm not going to give something away. I'm just going to sell it to my son for $1. For Medicaid purposes, that's going to be just the same thing as a gift. If you give it away or you sell it for less than fair market value, it's going to be considered a gift. I told you I was going to talk about estate recovery. And federal law requires all states, including Louisiana, to recover from the estate of people who have received Medicaid. And so, although the house, your primary residence, is not considered when you're qualifying for Medicaid, after the death of the Medicaid recipient or the surviving spouse, if there's a surviving spouse, the home property can have a lien placed against it, and Medicaid is going to want to be repaid for the money that they have spent on care. And so when you fill out a Medicaid application, there's some language at the bottom and some fine print that says, you understand by signing this, you're agreeing to estate recovery. For most people, the thing that's left in their estate is their home. And so a lot of times the children will have to sell the home in order to repay Medicaid. And so one of the things that we do is we do pre-planning. We plan more than 5 years ahead if we expect somebody is later going to need nursing home care, so we can start the running of that 5-year period. There are also some other tricks that we can use sometime. And I say tricks, all of the planning that we do is approved by the Medicaid. Is approved by Medicaid. There are just a lot of rules. There are a lot of exceptions to the rules. And so a lot of times we are able to save the value of the house either before or after that Medicaid lien occurs. And so I know I went really quickly through that, through those Medicaid rules. If there are any questions, let Christy know and I'll be glad to answer them at the end. The other thing that a lot of people are not familiar with are veterans benefits, and specifically something called aid and attendance. And where Medicaid is primarily used to provide care in a nursing home setting, you can use these VA benefits to pay for care at home, in an assisted living, or in a nursing facility. And it's just the veterans benefits are just benefits that are paid into your bank account every month if you qualify. And so Medicaid pays the nursing home. VA, if you qualify, just pays those benefits to you every month. And so you can use those benefits as needed to pay for care. And so let's look at the rules for the aid and attendance. So aid and attendance is a non-service connected benefit. And so when someone has a disability that they did not receive as a result of their service in the military, they may apply for and receive these aid and attendance benefits. For a single veteran, the amount of the benefit in 2020 is $19.12 a month. For a married veteran, it's $22.66 a month. And for the surviving spouse of a veteran who qualifies, the monthly amount is $1,230. Again, these numbers increase every year by the cost of living. And so there will be a slight increase in 2021 to these monthly payments too. The requirements for aid and attendance are that you have to have at least 90 days of active military service, with at least one of those days in a wartime period. You don't have to have been in a war zone. You don't have to have served in Korea. You don't have to have served in Vietnam. You just have to have been in the service during the time that those wars or conflicts were going on. You also have to be permanently and totally disabled or 65 and over and receiving Social Security. You have to have income less than the maximum benefit amount, but the way that VA counts income is different than the way that we count income. They count income by taking your income and subtracting from it all of your medical expenses. So when someone needs care, a lot of times their medical expenses are greater than their income, and they will qualify on this income test, even if their income is fairly large. There's also an asset test for aid and attendance. And for Aid in attendance, regardless of whether you're married or you're single, you can't have any more than $129,094 in assets. This is also a number that increases every year. So next year it'll probably be 131,000 in assets to qualify. Up until 2018, people could engage in planning and immediately get these aid and attendance benefits. They could transfer assets, they could transfer their house to their children, and then they could immediately apply for aid and attendance with the VA and get these benefits. At the end of 2018, the VA imposed a 3-year look back period for giving away assets or selling assets for less than fair market value. And so now when you're doing planning for VA, you need to be looking ahead at least 3 years, or you need to, if you're in a crisis, we have to look at what the best way to get qualified for those VA benefits are. The way that the VA calculates the penalty period is complicated. It's kind of beyond the scope of what I'm going to talk about today, but just remember, if you're reading anything that's a few years out of date and it says there's no gifting penalty, that was the rule until the end of 2018. Now there is a 3-year look back period in order to qualify for aid and attendance benefits. So I'm going to move now into planning for incapacity. This is also another area that's really, really important and maybe more important than the will. That's because we know that people with Alzheimer's, people with other diseases of a long trajectory, like Parkinson's or ALS, we know that at some point in time, they are probably going to become incapacitated and they're not going to be able to make their own financial decisions or their own healthcare decisions. And when that happens, we want to make sure that we have properly executed documents in place and that those documents have all of the right language in them. So the documents that are crucial when you're planning for incapacity here in Louisiana are you want to make sure you have a power of attorney that appoints someone to make financial decisions for you. And more often than not, you'll hear that called a durable power of attorney. What that word durable means is that the power of attorney survives even if you later become incapacitated. So very, very important to have a power of attorney for financial decision making. It's a good idea to have someone appointed as an agent to make decisions for you if you can't make those for yourself. And it's always good to have at least one backup person or one successor agent, just in case that person that you've appointed to act for you is unable to do so for some reason. You'll also want a healthcare power of attorney or a document that appoints someone to make healthcare decisions for you. You may want different people to do that. You may want one person to make financial decisions, a different person to make healthcare decisions. Those skills aren't always the same. And a lot of times I meet with families and they have one person maybe in the medical field that they want to make healthcare decisions for them. And then they want somebody else to make those financial decisions. Another really important document is a living will. And a lot of times people will confuse a living will with a will. A will is a document that says what you want to happen to your property when you die. A living will is a document that says if you're being kept alive artificially and there's no reasonable chance that you're going to recover, that you don't want to be kept alive in that manner. And so a lot of people want to have a living will in place to make sure that that they're not kept alive artificially if that ever occurs. I know that a lot of people have been looking at these documents recently. I've had a lot of people call my office since COVID, since early March, April. People, a lot of times they executed these documents, they put them away, never really thought about them again. But when healthcare and getting sick and needing a ventilator and being on life support, when those things are top of mind, people have pulled those documents back out and they've said, maybe I need to make some changes. What I thought was or what worked 10 years ago doesn't work anymore. And so I want to change who I'm appointing. And so these are documents that you should look at regularly. I recommend to my clients that if nothing changes in their life, they probably want to update these or look at updating these about every 3 years. Not necessarily updating them, but just looking at them to make sure that they still do what you want them to do. Another important document to plan for incapacity is a HIPAA authorization. And a HIPAA authorization is just a document that says who has the right to access your healthcare information, not necessarily who has the right to make your healthcare decisions, but who can access your information. And so a lot of times I'll have a client who has maybe 3 or 4 children. They want one of those children to make their healthcare decisions, but they're all right with having all of the children able to access their healthcare information in case they need to pick up a prescription and talk to the pharmacist, or possibly call the nurse or talk to the doctor or something like that. We want all of those people listed on the HIPAA authorization so they can get information about your healthcare. As I said, planning for incapacity, having this durable power of attorney is one of the most important things that you can do. It's going to allow your agent to step in and to make decisions for you when you can't do that. There are 2 ways that you can do it. Here in Louisiana, you can have an immediate power of attorney. And so as soon as you sign it, it becomes effective and your agent can go out and use it. The other way is to have something called a springing power of attorney. And a springing power of attorney doesn't become effective until either your agent and your doctor say you don't have the ability to make decisions anymore, or 2 doctors say you don't have the ability to make decisions anymore. At that point, that power of attorney springs to life, and that's why we call it a springing power of attorney. Here in Louisiana, there are about 9 or 10 things that have to be expressly written into the power of attorney in order for your agent to be able to do them. A lot of times I see powers of attorney that they're very general. And it says, it might say, my agent can take care of all of my financial decision making. Unfortunately, here in Louisiana, that's likely not going to work because you have to have some things expressly written into that power of attorney. I don't know if I have any examples. No, doesn't. Yes, I do. One of the things that has to be expressly written is for your agent to be able to make healthcare decisions for you. So if your power of attorney doesn't say your agent can make healthcare decisions, they're not allowed to do that. You also have to have in your power of attorney, the right to sell real estate has to be expressly given, the right to make gifts, the right to create trusts. Again, there's about 9 or 10 things. And if they're not in those powers of attorney, then your agent can't do it. Unfortunately, a lot of times, by the time I see the power of attorney and realize that it's missing something, the person who's given the power of attorney no longer has capacity to change it. And so we're stuck not being able to implement some of the planning that people could otherwise implement. A living will, as I said, is a document that documents your wishes concerning prolonging your life through artificial means when there's no reasonable chance for recovery. There's also another document, and it's not a legal document, but it's something I think you should be aware of, and it's called a La Poste document. And La Poste is a physician order that directs what your preferences are regarding your medical care when there's a life-limiting and irreversible condition. This is a document that your doctor is supposed to discuss with you, or if you're the agent for someone or you're helping someone with their healthcare decision making, the doctor's supposed to discuss it with you when they believe that you have 6 months or less to live. A lot of times doctors say, well, I can't really tell whether the patient has 6 months. So maybe if they feel like a year or less to live. This, again, is a physician's order. It goes into your chart and it is very detailed about the type of care that you want. Do you want to be resuscitated? Do you want antibiotics given to you? It goes into detail. It's printed on a gold piece of paper, and it's supposed to transfer with the patient across all of their healthcare settings. So they may be in the hospital. It's supposed to be there when they move to a rehab or the doctor's office, wherever they are. This little post document is supposed to be a part of their file. La Poste is supposed to present a model program for end-of-life care. I don't know what other people's experience is with it, but from my experience, it's not being used probably as effectively and as often as it could be. But this is a law that came about in 2012. And so possibly doctors will get more used to it, and it will be used more often also. Remember, I said that I believe that having these powers of attorney in place may be one of the most important things that you can do. The reason I believe that is because if you don't have these documents in place and you lose capacity, it may be necessary to file an interdiction. And an interdiction is what most states would call a guardianship. And that's a lawsuit that you file against your loved one, and it says, my mom or my dad or my wife or husband no longer has capacity, judge, and now I need you to appoint me to make decisions for them. It's a regular lawsuit, and so you're going to have to hire an attorney. The attorney is going to draft the paperwork. They're going to file it with the clerk of court's office. The clerk of court's going to send it over to the sheriff's office, and the sheriff is going to go out, and the sheriff's deputy, and hand it to your loved one and say, you've been sued. Here is the lawsuit that says you've been sued, and somebody is trying to take over as your guardian, or what we call in Louisiana a curator. Like all lawsuits, an interdiction can be costly and very time consuming. Additionally, once a curator or a guardian is appointed, we're not able to engage in any of that veterans or Medicaid eligibility planning because the person appointed can no longer give away assets. And most of the time when we are doing planning, we are doing some gifting in order to get somebody qualified. It has to be done very carefully though, because of those penalty periods that we discussed. And so the reason that I think powers of attorney are so important and healthcare directives are so important is because you can avoid this interdiction more often than not if you have those properly executed powers of attorney and healthcare directives in place. So the last thing I'm going to look at are some pitfalls in senior planning. As I'm talking about this, I'll also talk about wills and trusts a little bit. Looks like I've got about 3 hours left to talk, right, Christy? And so I should have plenty of time to get through this material. So one of the things that I see most often are joint ownership issues. And so people come to see me and they say, well, I'm just going to put my son's name on my bank account. Well, that's great, unless your son has, he may have creditor issues. Or maybe you put his name on there and he gets divorced and his wife now wants half of the money in your bank account. Or maybe he gets in a car accident and somebody sues him. That could subject your money to the claims of his creditors. Another thing I see is that sometimes people will say, well, I'm going to give something, or I'm going to put one child on ownership of an asset. And I know when I die, they're going to give their brother or their sister what they're entitled to. I hate to tell you this, folks, but once you're gone, your children, if they agree now, they may not agree in the future. So I had a case many years ago. It occurred in Iberville Parish, and it was an aunt and uncle. They had no children, but they had 2 nieces. And they wanted their nieces to both inherit some CDs that they had. And so they went to the bank, and the lady at the bank said, well, just put one of your niece's names on the CD. And then when y'all die, they'll be hers and she can give them to her sister. She can give half of them to her sister. Well, guess what? they died, and the niece that they put on there as the owner now said, well, wait, no, they wanted me to have all of that. And so it's mine, and I'm not going to give it to my sister. Now, fortunately for the sister, they didn't do it in the correct way. And so she ended up getting her half, but they had to go through court, pay a lot of attorney's fees to get the result that they should have gotten anyway. But a lot of times by putting joint ownership on something, you can defeat the provisions of your will or your trust. There are also some increased tax liability issues that again are beyond the scope of what I'm going to talk about today. But when you give assets away or you list somebody as a joint owner, they could face some increased income tax liability in the future. The other thing that I see that is often a problem, and something we try to correct if we have time to do that, is a lot of people have a will that says, when I die, I want everything to go to my spouse. And when my spouse passes away, then we want everything to go to our children. While that is a perfectly legitimate way to leave your property when you're well, if one of the spouses needs nursing home care and we've gotten that spouse qualified for Medicaid, or maybe we've gotten them qualified for VA benefits, if the spouse dies and the spouse in the nursing home inherits everything, they may be disqualified for Medicaid or VA because they now have too many assets. And so one of the things that we often do, instead of leaving everything directly to the spouse, we will create a trust, either an irrevocable trust or something called a special needs trust. And we'll have the well spouse leave their assets into this trust. So it will be there and can be used for the spouse who's in the nursing home if the well spouse dies first, but it won't count against their asset limits. And so that's just one of the ways that we use trusts in order to plan for Medicaid or VA and making sure that we're able to keep the person qualified. As I said, we also use irrevocable trust for pre-planning. And so if somebody comes to me, at least, and none of us knows when we may need nursing home care or when we may need long-term care, but if they come to me and they are still in fairly good health, or maybe they've recently been diagnosed with Alzheimer's, and we know that Alzheimer's is generally a disease of a long trajectory. People are going to be able to make decisions for a long time before they're lose the capacity to do that. We may create a trust and we may move some of their assets into that trust so that if after 5 years they need nursing home care or they need some other type of care, we can apply for those Medicaid benefits or those VA benefits. And so a lot of times when we are doing long-term care planning, we're using trusts. We may use trusts instead of a will, or we may use a trust in a will and a will. It just depends on the particular circumstances. So a lot of times people still ask about inheritance taxes or death taxes. Just to let you know, Louisiana doesn't have any inheritance tax anymore for anyone who died after June 30th, 2004. In fact, I think it doesn't really matter when you died now in Louisiana. There's no inheritance tax, and there's no federal estate tax due unless somebody's estate is worth more than $11.58 million. For a married couple, that number is about 23 million. Now, something to look for in the near future is there are likely to be some changes in the federal estate tax. If you see a Democratic president, a Democratic Congress, that number is probably going to go down quite significantly. Until this 11 million number is recent. It's supposed to go away in 2026 and go back to the levels where we were before, which is more in the $5 to $6.5 million range. So if you have a large estate, you just want to make sure that that you keep up with the federal estate tax. It doesn't affect that many people anymore. So I got through this material pretty quickly, a lot quicker than the 3 hours I anticipated. Christy, looks like we've got about 15 minutes left or so for questions and answers, if there are any. And before we do that, Christy, let me a little caveat here. There's no attorney-client privilege among the people who are on this webinar and me. And so I can't answer questions specifically about your case, and I may not have all of the facts. So I don't want to answer questions specifically about your case. I will be glad to answer any general questions you have about VA, Medicaid, long-term care planning, wills, trusts, powers of attorney, anything else. So
okay,
if I know the answer.
Thank you so much, Linda. And I mean, that was a great presentation. And again, I'll tell you that I would consider legal questions in the top 5 questions that we get at the office. And I know that I'm not equipped to answer that, so I usually refer that to Linda. I'll send Linda an email. Linda, can you answer this? Or what should we do? What do we need to tell her? Most of the time, we just refer to talk to Linda and other law attorneys face to face. So thank you again so much for taking the time out, Linda. We do have a few questions, and so I'm going to read them to you.
Okay.
The first question, if my loved one already has been diagnosed with Alzheimer's, can we still get a power of attorney, or is it too late?
That's a great question, and it's a question that I get a lot. In order for a power of attorney to be valid, a person needs to understand what they're doing. They need to understand that they're giving somebody the right to make decisions for them. And so if their Alzheimer's or other cognitive decline has not progressed to the point where they can't understand those things anymore, they can likely execute a power of attorney. The person who's going to make that decision about whether or not they have the capacity to execute a power of attorney is the notary who is notarizing the document. And so, again, I often meet with people who've recently been diagnosed or in the first few years of an Alzheimer's diagnosis, and they still have the capacity to execute legal documents. It certainly is something you want to get done as quickly as possible, just in case that capacity diminishes.
Okay. Thank you, Linda. I have another question for you. Can an adult child of someone with Alzheimer's be held financially liable for their parents?
The answer to that question is typically no. We are not liable for anybody's debts other than our own. There have been instances, though, where children contractually obligated themselves for their parents' debt. And so I had a case where a son went to a nursing home and his mom needed nursing home care. And they put the contract in front of him and he thought he was signing as an agent under her power of attorney. The nursing home claimed that they thought he was signing in his own name and was obligating himself to pay those costs. And they actually got a judgment against him. And so it's really important that if you are acting as someone's agent under a power of attorney and not yourself personally, you make that very clear, both in verbally, but more importantly, that you make it clear in writing, that you always put behind your name agent for so-and-so, so that nobody can come back and claim that you're acting individually and guaranteeing a debt.
Oh, thank you so much for that answer. I mean, it's a lot of great information. If you have any other questions, please add it to the chat box. I will tell you, even though that this presentation is really geared to people that are caring for individuals with Alzheimer's, you know, these legal documents are important for everyone. We should all be working
Yeah,
on it, or like Linda said, updating and revising them, whatever. It's really important. And I'm pretty sure if you have any questions after this presentation for Linda, if you can send them to me, and I can forward them to her, or Linda, you can call Linda's office. What's the number again, Linda?
let me see. There's a slider. Our number is 744-0027. I don't know what y'all are doing with regard to offering consultations and things like that, Christy. If somebody calls my office, we're going to run them through our regular process to schedule an appointment with me. If people do have questions after the presentation, I did go through this material quickly because usually I'm running long. And so I wanted to make sure that I got everything completed. If you have some additional questions and you just want to send those over to me, Christy, and I will be glad to answer them. And then you can send them either back to the person who asked you the question specifically or out to the whole group. I'll be glad to do that.
Absolutely.
And again, they can call our office and schedule an appointment to talk to me or our other attorney. If they're interested, the number is 744-0027. Email us at services@legacycenterla.com. Any other questions you have, Christy? Anything else that?
No, I think that's it. And it was, you said it went very quickly, but it was very thorough too. So, we appreciate that so much.
Yeah, it's rare that I finish early. So I'm feeling kind of lost here.
I know.
I can go on talking for a while. So, I want y'all to get your money's worth.
Yeah, and we do have some comments. Someone said, typed in, great job. So
great.
Definitely, I definitely thank you so much for taking the time out again and sharing the information. Someone else said, wonderful presentation. Thanks, Linda. And I thank you too, Linda. And I'd like to thank.
Yeah, and like I said, if you have some additional questions. A lot of times it's going to take a while for this stuff to sink in. Feel free to send me those questions over and I'll be glad to answer them.
Absolutely. And thank you guys for attending this workshop. This is our final workshop for 2020, our first virtual series, and it wasn't that bad. Some learning curves there. I'd like to thank Ellen Dunn for her technical expertise in helping us workshops, our social worker and our tech support at Alzheimer's Services. And I just have a few reminders, you guys, as we conclude November Awareness this week. On November the 19th, we will be hosting a Q&A panel that will be facilitated by Gina Rossi, and our guest panelists include Dr. Jeffrey Keller from Pennington Biomedical Research Center, Sergeant Elvin Howard from the East Baton Rouge Police Department, Paula Oder of Lineage Law, former caregiver and education committee member Terry Robillard, and current caregiver and board member of Alzheimer's Services, John McClellan. So don't miss out on that. Registration is still open. And again, that panel will be 12 o'clock on this coming Thursday. And we also have virtual memory screening still going on. Our last day would be this Friday from 9 to 12. Please, if you're interested in a virtual memory screening, call the office to get more information. I would also like to thank all of my speakers for financial literacy: Tasha Stockwell, April Brown from the Attorney General's Office, the Medicaid Control Unit, Maria Alvarez from the Social Security Administration, and Linda Melancon from Legacy Estate and Elder Law Center. We appreciate all of you. And a special thanks to all of our sponsors for November Awareness: Keen Miller, Dupree Pharmacy, Azalea Estates, Hospice in Its Care, Notre Dame Hospice, and Ascension Oaks for all of their support this month. We appreciate you guys, and please know that we are here for you if you have any questions at any time about things that are challenges that you're going through during your journey. Give us a call, 225-334-7494. And you also should have my email. So come email us, whatever you have. Have a great holiday, you guys, and a safe holiday. Keep your mask on too, please. Thank you, guys. Have a wonderful day. Thank you, Linda.
Bye-bye, Christy. Talk to you later.
Bye, y'all.